Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is based on the disallowances under section 36 subsection 1 clause 5a, which is for the late deposit of employee share of ESI and PF beyond the due date prescribed on those acts. The issue in the present case is that whether there is any hope for those assessees whose disallowance under section 36 subsection 1 clause 5a has been done through the intimation under section 143 subsection 1 clause 5a before the judgment of the Honorable Supreme Court in the Checkmate Services Pvt Limited versus Commissioner of Income Tax on 12th October 2022. This important issue has been taken up by Honorable Chhattisgarh High Court in the case of Kumar Bothra versus Deputy Commissioner of Income Tax, and this case is reported in 476 ITR page number 249 and the date of the judgment is 8th May 2025. In the present case, the disallowance of the assessee was done through intimation under section 143 subsection 1 clause A on 16th December 2021. The moot question arises that whether this disallowance can be done under section 143 subsection 1 clause A. The very concrete answer to that query is that if on the date of the intimation, if any issue is debatable or rather highly debatable, then in that case the disallowance under section 143 subsection 1 clause section 143 subsection 1 clause A cannot be done. Now the question arises, when the Supreme Court has given a decision on that issue, so it means that that issue does not remain debatable, but the Supreme Court gave its judgment on 12th October 2022, and in the present case the intimation was sent on 16th December 2021. So from the facts and circumstances of the case, it was very clear that on the date of intimation, that is 16th December 2021, the issue was highly debatable, and on that date the assessing officer was not having any jurisdiction or a legal power to make that disallowance under section 143 subsection 1 clause A, but he made the disallowance. The assessee filed the appeal before the CIT appeal, and the CIT appeal also upheld the intimation under section 143 subsection 1 clause A, and on the same grounds the tribunal also upheld the intimation and the order of the CIT appeal. The assessee filed the appeal before the Honorable Chhattisgarh High Court, and when this matter was heard by the High Court, it was the viewpoint of the court that on the date of intimation, there is no denying the fact that the issue was highly debatable, and the ground of the revenue that the disallowance was mentioned in the audit report. For that, the court said that the disallowance was not mentioned in the audit report, only the date of deposit and only the due date has been mentioned, but specifically no disallowance was not mentioned. So in that case, it cannot be said that the disallowance was very apparent from the books of accounts of the assessee or the tax audit report or the return of income. So this case is very helpful for all those cases in which the intimation has been sent to the assessee dated before 12th October 2022, that is before the Honorable Supreme Court judgment in the case of Checkmate Services Pvt Limited versus Commissioner of Income Tax on 12th October 2022, and which is reported in 448 ITR at page number 518. So there is no denying the fact that before that date the issue was debatable, and the revenue cannot make the disallowance under section 36 subsection 1 clause 5a through the intimation. The court said that if the revenue wants to make the disallowance, then the revenue should have taken the approach of section 143 subsection 3 proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Kumar Bothra versus Deputy Commissioner of Income Tax, and this case is reported in 476 ITR at page number 249, and the date of the judgment is 8th May 2025. Thank you, friends.